Judge loses it after Blake Lively's shocking courtroom stunt. And no, this one didn't need a Netflix budget to go viral. She showed up like she owned the place only to pull the plug on 2 of her own claims mid-hearing. So was all that drama just promo for her next Betty Booze bottle, or is the case already falling apart on her end? Blake Lively stepped into Department 84 of the Los Angeles Superior Court for what was expected to be a procedural formality. Her appearance was tied to the ongoing pretrial discovery phase of the defamation and harassment lawsuit she filed against director-actor Justin Baldoni. The actual trial was slated for mid-2020s, but due to the volume of motions filings and counterfilings submitted since late 2024, the court mandated Lively's presence on paper. The day's hearing was focused on clarifying her decision to drop 2 original claims, one for emotional distress and another for intentional infliction of trauma. But by the end of the morning session, it was no longer a routine pre-trial check-in. It became the moment the courtroom turned against her. What happens when a celebrity's carefully constructed narrative unravels under oath? The first sign of tension came when defense attorney Ellen S. Jarapalo filed a motion to compel Blake Lively's medical records from 2022 to 2025. Goof, a seasoned trial lawyer known for her role in the Anna Nicole Smith probate battle, argued that if Blake's claims of emotional distress were valid, there had to be a corresponding psychological or psychiatric trail therapy sessions, hospital visits, prescription histories. This was not a fishing expedition. It was a foundational check. In any civil claim involving mental anguish, such documentation is the evidentiary spine. But instead of responding with medical disclosures or a protective order, Blake's legal team took a dramatic pivot. Why would someone claiming deep emotional trauma choose to withdraw their claims the moment they're asked? To prove them, Blake's attorney Raymond Keller calmly addressed the court and announced their decision to withdraw both emotional distress claims, the very ones that had initially drawn massive public sympathy. His explanation, delivered without notes, was brief. We are choosing to focus the case on the more egregious sexual misconduct elements which we believe are central to the harm endured by Ms. Lively. But this strategic narrowing, delivered with the composure of a press release, did not sit well with the court judge Robert D. Hathaway, a veteran of the California bench who presided over the 2017 James Franco civil defamation hearings, furrowed his brow and leaned forward. The optics were clear. Something didn't add up. Is this a legal tactic or a calculated retreat from a lie that could no longer be sustained? Judge Hathaway's unease soon turned into open frustration. He paused. The hearing removed his glasses and addressed the court bluntly. If this court is to entertain claims of psychological trauma, then this court expects evidence. You don't get to make headlines and then walk back allegations because you've been asked to substantiate them. The judge's remark drew visible reactions from the press pool court. Reporters from the Hollywood Brief, Deadline Legal, and TMZ Trials and Laws shifted in their seats. In just a few minutes, what was meant to be an administrative motion had turned into a credibility referendum on Blake Lively's entire case. How often does a judge publicly challenge a plaintiff's honesty in open court? The underlying legal issue wasn't minor. California's Civil Code section 3281 allows plaintiffs to claim damages for mental suffering, but only if they meet evidentiary standards. A claim of emotional distress without corresponding evidence isn't just weak. It's potentially abusive of the court's time and the defendant's resources. GOP seized the opportunity. The implication was unspoken, but Loud Lively's legal team either never had evidence or feared what it might show. Is the silence of evidence louder than the claim itself? Adding to the courtroom shock was the timing. Just 2 weeks prior, Blake's team had made multiple media appearances affirming the mental toll the alleged harassment took on her. She described herself as emotionally wrecked in an interview with Variety, and her spokesperson told Vanity Fair that she had been under constant psychological pressure since the onset of the misconduct. And yet, when asked to prove that trauma before the one body that truly mattered, the court, She chose to bow out. The contradiction was not lost on Judge Hathaway, who noted aloud, "Statements made to the media carry no legal weight in my courtroom. When legal, reality collides with celebrity PR. Which version survives?" What also stood out was the lack of internal alignment within Blake's legal team. While Keller attempted to steer the discussion toward the sexual harassment claims still active and under evidentiary review, his co-counsel Vanessa Ortega appeared flustered. Observers noted her rapid flipping through case files and her whispered exchange with their junior associate. It became increasingly evident that the withdrawal had not been discussed at length internally, raising the possibility that Keller acted unilaterally. This added yet another layer of doubt to the court's already dimming confidence in the plaintiff's consistency. How fractured must a legal team be to implode? In the middle of its own case, as the hearing wrapped, Judge Hathaway issued a chilling reminder. He warned Lively's team that any further withdrawal of claims without satisfactory evidentiary clarification would trigger Rule 11, review a legal mechanism, designed to penalize parties for frivolous filings or bad faith litigation. For a celebrity plaintiff, that's not just a procedural risk, it's a public condemnation. And if that happens, Blake Lively won't just be walking back claims. She'll be walking into a legal trap of her own making. The moment Judge Robert D. Hathaway slammed his gavel, the courtroom air shifted, his voice firm, but boiling with controlled fury, echoed across the wood-paneled chamber. "This is a court of law, not a publicist's rehearsal room." The words weren't metaphor. They were a direct accusation. Blake Lively's legal maneuver, withdrawing major claims the minute hard-P proof was requested, wasn't just suspicious, it felt orchestrated. And Hathaway, who had tolerated months of celebrity theatrics with professional restraint, finally snapped. In that instant, it was no longer about motions or legal strategy. It became a war for the court's credibility itself. When a judge questions the entire foundation of your case, what does that say about your truth? What followed was not a gentle clarification. It was a judicial reprimand. Judge Hathaway leaned into Lively's legal team with precision. If your client was medically traumatized, where are the evaluations? Where are the therapists? Affidavit, where is the trail of evidence? His voice was steady, but each word cut through the courtroom like a knife. It was the kind of questioning usually reserved for hostile witnesses or perjured defendants. And when Raymond Keller tried to interject, with procedural jargon, Hathaway cut him off cold. "This court does not exist to rubber stamp your headlines," he said before threatening to invoke Rule 11 sanctions if any more frivolous filings appeared on his docket. How often does a sitting judge accuse a celebrity of weaponizing the courtroom for personal branding? Rule 11 of the Federal Rules of Civil Procedure isn't just a slap on the wrist, it's a legal grenade. Its purpose is to punish attorneys who knowingly submit false, misleading, or reckless claims. Hathaway made it clear if Blake's withdrawn emotional distress filings were found to be knowingly fabricated or exaggerated, her team could face penalties, dismissal of claims, or even disbarment proceedings. The message was crystal clear to every legal analyst in the room. This wasn't just about one dropped claim anymore. It had triggered a full-scale credibility audit. And if her case is now under audit, what else might be exposed just hours after the hearing? A formal court order was issued. Hathaway demanded a transcript review of all filings submitted by Blake Lively's team since December 2024. It included affidavit, public statements, court motions, and even evidence logs. According to internal court sources cited by the Daily Jurist, the judge privately requested a cross-match between Blake's public statements to press outlets and the legal language used in her court documents. The implication that Lively's team may have used the court to fabricate or exaggerate claims simply for reputational leverage. When the media strategy becomes indistinguishable from the litigation strategy, has the law already been compromised? It didn't take long for the ripple effects to hit. That same afternoon, Justin Baldwin's legal team filed an amended countersuit against Blake Lively. The new charge: strategic defamation for financial advantage. At the center of their case was a damning timeline. Interviews Blake gave to the Cut Entertainment Weekly and Vulture Her. Words in those interviews, according to the Counter-Ute, went beyond commentary and into deliberate character assassination statements about Baldoni that were never included in the official complaint, and therefore never subject to legal scrutiny. Could this be the first time a celebrity gets countersued for defamation inside their own defamation case? The legal community responded with disbelief and urgency. Professor Talia Jennings, a senior litigation scholar at UCLA School of Law, went on record with the Daily Jurist, stating, "If Blake knowingly fabricated or exaggerated any claim under oath, it could constitute perjury. And if her team aided that exaggeration, they could be charged with obstruction or conspiracy." Jennings wasn't being speculative. California Penal Code allows perjury charges in civil cases where false statements materially impact a legal proceeding. And unlike typical celebrity scandals, this was no longer just tabloid fodder. It was now a potential criminal matter. What started as a civil suit over misconduct could now drag its star plaintiff into criminal court. To prevent further spiraling, Judge Hathaway also imposed a hard discovery deadline. Both legal teams must submit all remaining evidence: emails, texts, witness depositions, therapy records, production set, security footage within 14 business days. This wasn't merely a procedural demand, it was a pressure test Hathaway wanted to see under threat of court sanction, which side actually had substance behind their accusations. Legal experts note that such a deadline under duress often exposes inconsistencies or hidden weaknesses in either party's position. What kind of truths emerge when the clock is ticking and there's nowhere left to hide? Blake Lively's case, once heralded as a bold stand against industry abuse, was now collapsing under the weight of its own contradictions. Public sympathy was fading, judicial patience was exhausted, and legal accountability had officially entered the room. What happens next could decide not just the outcome of a lawsuit, but the future of celebrity litigation itself. Within hours of Judge Hathaway's outburst, the Court of Public Opinion issued its own verdict on June 2nd. Alone, the hashtag Blake Lively lies trended for over 7 consecutive hours, on amassing more than 820,000 retweets before noon. What had begun as a curiosity over Blake's withdrawn claims swiftly mutated into full-scale backlash. Social media wasn't asking whether she was telling the truth. It was mocking the very idea. Users began reposting clips of her emotional red carpet interviews from 2020, overlaying them with captions like, "Oscar-worthy, but not court-worthy." And for the first time in this legal circus, Blake had no script to follow. When the fans who once cheered for you become your prosecutors, who do you turn to? The damage didn't stop at memes. BuzzFeed Legal published a scorching editorial titled, "Blake Lively, the Amber Heard Playbook Revisited." The article drew direct parallels between Blake's withdrawn trauma claims and the now infamous 2016 Amber Heard deposition scandal, where emotional testimony later unraveled under cross-examination. The timing was brutal, but strategic. BuzzFeed backed its critique with a side-by-side of Lively's TV interviews and court filings, pointing out glaring contradictions in her version of events. The implication was clear. The public wasn't just watching, it was connecting the dots. Can a narrative survive when its contradictions are made viral by the evening matters worsened? A leaked text thread allegedly exchanged between Blake and her longtime PR manager Stephanie Jones began circulating through independent legal blogs and celebrity watchdogs. In the thread, Stephanie allegedly writes, "Drop it. We'll win hearts with the harassment angle." Anyway, if authenticated, the message would confirm what Judge Hathaway had already hinted at, that the emotional distress claim was never meant to stand trial. It was there for optics. The PR firm Jones works already under fire for its media management. Of several celebrity lawsuits refused to comment, but the silence only fueled speculation. And if your own PR manager treats legal claims like headlines, what does that say about their truth? The numbers didn't lie either. According to YouGov Celebrities, Blake's public favorability rating plunged from 64% in April to 41% in June, marking the steepest drop in her career. For context, that's a sharper decline than Ellen DeGeneres experienced during her 2020 workplace scandal. Sponsors began quietly backing away. Fashion brand Maison du Loup, which featured Lively as the face of their 2025 spring campaign, deleted all promotional content featuring her by the next morning. The industry wasn't waiting for a verdict. It had already decided she was too risky. How fast can fame turn into fallout when silence isn't an option? In a desperate attempt to regain control of the narrative, Blake's legal team organized an emergency press conference outside the courthouse steps. Her attorney, Raymond Keller, stood in front of a sea of microphones and claimed that Blake had every legal right to narrow her focus. He stressed the evolving nature of complex litigation and dismissed media speculation as grossly irresponsible. But the statement lacked. Bite reporters weren't interested in legal nuance. They wanted to know why the emotional claims had vanished without a trace. And Keller had no answer that didn't sound like spin. Can a press conference undo what an open courtroom has already revealed? Behind closed doors, the situation was unraveling. Sources close to the case confirmed a growing rift between Blake and Keller. Apparently, Keller had privately threatened to withdraw representation if Blake continued making erratic decisions without strategic or legal foundation. Insiders at Keller and Marks LP revealed that the firm's managing partners had raised serious concerns about the reputational damage being inflicted not just on their client, but on the firm itself. The legal community was watching, and no one wanted to be remembered as the firm that gambled its name on a collapsing celebrity case. What happens when even your own lawyer doesn't want to stand beside you? Making matters worse, efforts to bring in Taylor Swift as a character witness, something Blake's team had considered a PR win, abruptly collapsed. Though Swift had privately expressed support in 2020 for it, her team reportedly pulled out due to unmanageable reputational exposure. Swift's involvement was meant to provide credibility to Blake's account of alleged toxic dynamics during the 2023 production of It Ends With Us. Instead, the withdrawal signaled something else entirely.